lawyers here from LegalVision, and I'm going to get them to introduce themselves in a second. But just so we can get a good understanding of who we have here today, can I just get a show of hands? How many of you have been to a LegalVision event before? Great. First time? How many of you here for the first time? Okay, wonderful. That's good. That'll help us work out what we're going to say tonight, what we're pitching to. And so I'm going to start with getting these guys to introduce themselves. Can you tell us your name, what you do here at LegalVision, how you work with clients, and maybe given the topic for tonight, if you could tell us what's the most common mistake or something you see in your area that startup founders make.
Hi everyone, my name's Tom Linnane. I'm one of our corporate and tax lawyers here at LegalVision. So when it comes to what I do with our clients, it's really advising on tax matters at all stages of the business journey, from the initial structuring side of things to the more complex tax issues that happen as businesses start to mature. So things like bringing on investors and what concessions might be available there, all the issues that can come up with employment taxes, and then eventually, international tax and restructuring issues as the business progresses. So a very wide range of things that we advise on in the tax team. When it comes to the biggest mistake that I see clients make, it's a bit of a broad sweeping statement, but it's the assumption that just because a business is small or if it's a startup that tax doesn't matter. And then, separately but related to that, it's that because you're a small fry doesn't mean that the ATO won't look at what you're doing. So yeah, it's important, just as important as contracts and intellectual property. Definitely something to get right.
Everyone, my name is Stephen. I'm a practice leader in LegalVision's commercial and regulatory team. My sort of day-to-day is very broad. Contracts is obviously a main focus, but also kind of general, business compliance and legal compliance in your operations. So I support a lot of businesses on things like financial services compliance, carbon credits, consumer law, privacy, data, all those sort of things. In terms of the common things that I see, or I guess the worst thing that I've seen is the kind of, in the rush to get a deal done and get a deal signed, not having a contract reviewed and not understanding what the contract is. A lot of times contracts might not actually be fit for what you're trying to achieve. And it'd be surprising the amount of conversations that I have with founders and clients where they think they've got a contract that does one thing, but when you actually read it, it does something completely different and it's not even related to what their particular transaction or requirement is. So that's sort of the one that comes up pretty much every day. So yeah.
Hello. Hi everyone, I'm Sophie. I'm one of the senior lawyers in the trademarks team here. So my day-to-day looks like looking after clients throughout the whole trademark registration life cycle, so from application through to registration. And we also assist clients on like an international basis as well, in terms of looking after their kind of international brand portfolio and working with overseas associates. A mix of clients from startup through to enterprise level, and also assisting with kind of oppositions and disputes in the IP space as well. One of the biggest mistakes I see for startups really is getting the distinction between business name registration and trademark registration wrong. So often I see clients who will think that because they've got the business name registered, that means that they have exclusive rights to use the name. There's a completely different registration process, and that's what my team deals with, and they kind of work alongside each other. So it's really important to get both registered and get both registered right. So that's what we'll discuss in a bit.
Thank you. So our plan for tonight is to take you through some tips and some strategies, particularly in working out how to choose the right business structure for your business to make sure that you can optimize growth as well as tax. As well as how you can safeguard your business using contracts, so both your client agreements, service agreements, employment agreements, as well as protecting the brand that you've invested in and making sure that it's in a good position to grow and expand in that market. So I've got some of the most common questions that we come across from startup founders that I'll take us through with our lawyers. And then afterwards, we'll have an opportunity for some Q&A. So if things pop up as we're talking, please feel free to note them down. And later in the evening, we will come through with a microphone to ask those questions. before I get into that, one more question for all of you, and I promise it's the last one of the night. But how many of you have launched recently, maybe in the last 6 months? Yep. And how many of you are preparing for a launch? Okay, perfect. That's for you guys to know. So as you go through your tips, those are the people that you're talking to. So we'll start off. This one's for Tom in working out what are the most common business structures that we have available to us, and how do we pick the right one? What are some of the advantages and disadvantages of each of them?
Yeah, thanks, Danu. So, look, what business structure you ultimately end up with really comes down to a lot of different things. It really comes down to what you're looking to achieve, where your business expansion plans are going to take you. But I guess the four most common business structures that we see at LegalVision, at least, are your sole trader, which is very easy and simple to set up. It's a matter of registering an ABN and off you go. It is very simple, but ultimately a sole trader all falls back to you personally, so it's not the best when it comes to liability and asset protection, but also expansion. It's pretty limited in that way. You have a partnership as well, which is similar to a sole trader in that, it's quite easy to set up if you have other people working with you alongside you in the business. But again, everything starts and ends with the partners in a partnership, so it's not great for, say, expansion, but also asset protection. Especially if you're looking to expand, take on investment, and if you care about asset protection as many people do, a company is a very popular structure that we see at LegalVision. It allows you to bring on people quite easily. It's quite flexible, and it's very well known by people like investors. So if you are thinking about taking on investment, a company is a great structure to use. There's a lot of tax incentives that come with having a corporate structure as well, especially if the company is looking at doing something in the research and development space. There are particular tax incentives that are only available to a company, and then particular concessions that are available to investors who invest in an innovative company. And then we finally have our trust, which is, again, it's a popular business structure and does come with a lot of tax benefits, like being able to stream income to particular people in the business, but it's not the most flexible because any money left in a trust at the end of a financial year is taxed at a really high rate, which makes it really hard to, say, retain profits and reinvest that into the business. So those are some of the common business structures that we see at LegalVision. Which one you ultimately end up going with, as I said, really comes down to what you're looking to do, and there's never one size fits all approach to business structuring. So it's important that at the start of your journey, that's the type of questions that you should be asking, and something we'd work with you on to make sure that what you're looking to do and the structure is reflective of that and matches what you are looking to achieve.
And just in thinking through when a business first starts up compared to what they're planning to do, 6 months, a year, or even later down the track, at what stage is it important to get the business structure right? Like, can you set it up for where things are at now and then change later down the track? What would that look like?
Ultimately, starting a new business is very exciting, and people often want to move quite quickly. And so sometimes the business structure is the last thing that people think about. So you're not locked into one structure forever, and there are ways that you can restructure from one structure to another. For example, going from a sole trader to a company or a partnership to a company is quite common. You're not locked in forever. The actual process to get from one to the other on paper sounds quite simple, but there's a lot of things that you would have to think about and work through when it comes to the tax implications. Often you're talking about essentially selling one business from, say, yourself as a sole trader to another entity, being, say, a company, and there's a lot of tax things to work through in that. That's not all doom and gloom, though. There's certainly ways to think about how the transaction can happen in a tax-efficient way. And ultimately circumstances can always change within a business. Someone might start something as more of a side hustle, and then it blows up, and then all of a sudden one structure that might have been appropriate at the start is no longer appropriate. So definitely not locked in forever, and there are ways of restructuring later on. But it's important to talk to us at that point in time, to make sure that you're not hit with a massive tax bill at the end of the day from restructuring.
Thanks. And you did touch on this earlier, but I just wanted to get you to, can you spell out for us again? You mentioned that if you're thinking of raising funds and bringing on investors, that a company is the best structure. Can you talk us through what is it about a company that makes it more attractive to investors?
Yeah, no, definitely. So, I mean, at the end of the day, a company has what we call share capital. You can buy shares in a company. A sole trader is just a person with an ABN. You can't buy shares in a person. So just being able to give funds to a business is a lot easier with a company structure because there's just a lot more avenues you can take. If you don't have an ability to buy shares in a company, you're really limited to, say, taking on finance through some kind of loan or debt. So it's just more flexible in that way. But then, there are other incentives known as the early stage innovative company incentives, which if a company is considered an early stage innovative company, there are really beneficial tax incentives that are available to investors who invest in those types of businesses. So things like a 20% rebate in your personal tax return as an investor up to a certain cap, and special capital gains tax treatment for selling those shares. So if you hold them for a certain period of time, basically no capital gains tax implications if you sell those shares between certain times. So those particular incentives are only available for shares in a company. The legislation is pretty clear about that. So, saying, even if you have some kind of interest in a trust, even if that trust is doing innovative things, it's just not available. So investors are just more familiar with companies as well at the end of the day. So it's a mix of tax and also other more commercial reasons as to why companies are so popular. So yeah, there's a whole range of factors, but that doesn't mean it's not possible through other business structures. It's just the widest range of avenues are available in a company we tend to see.
Great. Thanks, Tom. You can rest for now. I'm going to ask Stephen some questions. So, Stephen, what would you say are the 3 most essential contracts that every business needs to consider?
Yeah, that's a good question. I mean, there's lots of contracts that a business will need for lots of weird and wonderful things. But to kind of group them into 3 main categories, it's contracts with your suppliers, so people who are providing inputs into your business. It's contracts with your customers, because they obviously are the ones that generate revenue and drive growth of your business. So getting that right is really important. And then the last category would probably be, contracts with the people that work for you, so your employees and your contractors. And I guess, in terms of, each one and how you tackle each, there's, I guess, a lot of different considerations that need to go into it. What is your revenue model? What are you looking to achieve? Is there any sort of data that you're getting out of those, customer contracts, for example, that you might need to be able to use in other ways or to scale the business? Those are the sort of things that you should be thinking about from the outset to try and kind of, work out what needs to go in. It can be very hard to use things like, and data's a really good example where if you haven't really gone ahead and thought about those things early enough, and you go ahead and sign all these contracts, it's very hard to then go back and try and get the right consents or permissions that you need to do what you need to do. And I see that all the time. And so understanding that is really important. Understanding, do you own, when you're working with a supplier, say it's a developer or maybe a manufacturer, do you own what they're doing for you? Do you have a right to actually commercialize what you're looking to commercialize? And if you're working with your customers, with your staff, have you actually classified them correctly? And do you know, whether an employee is actually an employee or a contractor is actually a contractor? So things like that are really important to get correct. And those are why, those are probably the 3 main categories, because if you get any of them wrong, the consequences can be quite significant.
And Tom, sorry, I actually told you to rest for a bit, but actually that brings up a really good point about the classification. Often with the contractors and employees, that has some tax implications. So maybe, Tom, can you talk us through, why is it so important to get that right, and what are some of those implications?
Absolutely, it's a huge pain point at the moment for a lot of businesses, especially when they are engaging contractors. So, I mean, in a nutshell, the issues arise because for tax purposes, there are a number of circumstances where a contractor can be considered an employee. And so this has been the case for a long time, but it seems like there's always been a bit of a misconception when engaging contractors that they hold an ABN and that's the end of the road. We don't owe them things like superannuation, or we don't have to withhold payments under the pay-as-you-go withholding system. So There are a number of factors that say the ATO would look to when making that distinction between whether someone is an employee or a contractor. Looking at things like how much control someone has over how and when they do the work. Are they able to delegate that work to someone else, or do they have to do it themselves? Are they just being paid for their time, or are they being paid to achieve a particular result? So when you start to work through those things, if the arrangement sounds and it's like it walks and talks like an employee, it doesn't matter if you call it a contractor. So if a worker is considered an employee for tax purposes, which can happen a lot with contractors, the business would have an obligation to pay superannuation to that contractor's nominated superannuation fund, or if they don't nominate one, they'd have to go and contact the ATO to try and find the fund to pay it into, basically. And again, it's a misconception that seems to be around for quite a while that, we're just going to pay you a grossed up amount, and say that's for you to go and deal with your own super. So that's not enough to basically extinguish someone's liability if they are someone who owes the contractor superannuation. Just like any employee, you have to pay a contractor's super directly to the nominated super fund. And so when it comes to the end of that and what that looks like if a business gets it wrong, at the moment the ATO is cracking down hugely on employment tax obligations. So they're auditing quite a number of businesses to see if they have gotten that classification correctly. And in the event that a business hasn't, and there's a big unpaid superannuation liability, those types of liabilities are liabilities that the ATO can make directors of companies personally liable for by issuing what's called a director penalty notice to the director. So it's a big obligation that businesses should be thinking about when they're engaging workers, in particular contractors, because ultimately it's one of the rare circumstances where the director of a company can be on the hook for the actions of a company if they get that wrong. And that also goes for things like pay-as-you-go withholding. If a worker is considered an employee for tax purposes, you have to withhold under the pay-as-you-go withholding like you would with any worker and any employee. So yeah, those are just some of the big ticket items when engaging contractors.
And Stephen, what are some of the most common, oversights or mistakes that people make, particularly in the early days of a business in relation to contracts? What are the things that they make the mistake of most?
Yeah, so a really common one for founders and startups is signing contracts in their own name and not the name of the entity that they've put blood, sweat and tears to set up and commercialize. So I have a lot of conversations and there's a lot of work that goes into, for example, you've gone ahead, you've got your developer or you've got your manufacturer and you've signed this wonderful contract, and then we have to go to the effort of trying to get that transferred and get your personal liability out of there and get your company in your place or your trust or whatever vehicle you've set up. So that's a really common one that we see. And then I guess in terms of that, kind of goes back to that earlier point that I think I mentioned with common mistakes. It's that the contract's actually not fit for purpose, or you haven't really understood what the contract is about, or is it reflective of the particular matter. And that usually actually comes up a lot in the commercials and the way in which the commercials are worded, because I've had a lot of conversations with clients where they have agreed maybe verbally or through a meeting discussion that this is what the commercial arrangement will be, and it's all built on good faith and trust and everyone's happy, and you leave that meeting thinking, wow, we've got this really good deal. And then you actually get the contract and they send it to us and they go, oh, you just do a legal review, we've already discussed the commercials, it's all fine. And then I've actually looked at that contract and gone, oh, okay, so that doesn't really actually make much sense commercially to me. Like, why are you, it was a business sale one actually where there was a success fee of $1 million. And I was like, oh, are you just, I'm assuming you're across this, but just checking that you're aware that there's this $1 million success fee, regardless of what the business sale value is, because they were engaging a business sales advisor. And they were like, oh, that's not what we agreed, or I didn't realize that was in there. And just things like that where, look, if you read them yourself and you check those things, you'll pick up on those things. But that's a really, just the amount of conversations I have about that is bewildering, because, you're in that kind of rush to get things done and you think that the lawyer sign off is kind of the formality, but oftentimes it can actually be where a lot of those things are captured. And that's in addition to all the standard stuff like the IP is not properly defined, or you don't know who actually owns it, or it doesn't transfer to you, or your liability is sort of through the roof and theirs is not, and things like that are kind of the common things. But yeah, it's a lot of the non-legal stuff actually pops up the most in terms of, you know, the commercials and, you know, is this contract actually the right one for this particular situation?
And apart from, you know, getting a lawyer to look over the contract, are there any tips that you can give people for what they can do if they receive a contract or if they want to prepare a contract?
Read it, like just give it a skim. Again, it's really surprising how many people don't. Just have a look for, if you've been given a contract that's 100 pages, God forbid, I think a 100-page contract doesn't really add much value, it's just waffle, but if you've got a contract of any length, just hit Control F, hit a $ in, hit a percent in, you know, check for those sort of things first. You might find some liquidated damages or some sort of penalties hidden away in there. Even put in the word dollar, you know, things like that. Some of those keywords are actually really useful for you to just kind of do that initial screen yourself to say, oh, is there actually something here that I should pay attention to? It's also good sometimes, even if, you know, will usually be worded in a very waffly and hard to comprehend manner, but even just typing in, you know, liability or, you know, even just LIAB, trying to spell, just to have a look at that liability section and just see, you know, it'll usually say something like if there's a liability cap, what that cap might be. Is it, you know, the fees paid under the contract? Is it $1 million? So you can understand, you know, what your risk is. Maybe have a look at the insurance, see what those insurance requirements are. A lot of clients, or a lot of contracts now we're seeing will have requirements for things like maybe advertising and media insurance, or cybersecurity insurance is a big one, as you might imagine. And so, you know, often we're kind of having to say, hey, these are the types of insurance that you're being asked to have. Do you have them? Oftentimes you don't, or the limits are too high for what you have, and the cost of increasing your premium for that would be probably worth more than the contract. So those are the sort of things that you can check yourself. And if you say to your lawyer, hey, I've already checked these, that will also just, you know, speed things along in terms of review. And if you are, you know, say for example, you've got a lawyer already and you're paying hourly rates, the less things that they have to check means the less that you end up having to pay. So that is also in your benefit as well.
Thank you, that's really helpful. I feel like I need to start doing the Control F on $ on when I click accept terms. So Sophie, we're going to move on to branding. Could you tell us what are the first steps that a business owner should take for protecting their brand and their intellectual property to protect it from competitors?
Sure. So, yeah, I mean, your brand is one of the most kind of fundamental parts of your intellectual property, and it's going to be one of the most valuable parts, most likely, of your whole business. But at the outset, you may be kind of considering a number of different brand names, and then eventually it's likely you'll kind of get tied to one name or a couple. So at that stage, I really encourage you to start doing some searches of the marketplace. And it's probably, you know, it's probably common sense to start just looking out to see what's there already. But you'd be surprised how many people want to kind of kick off a business with a name that's, you know, quite commonly used already in the marketplace. But on top of that, so, you know, some straightforward Google searches. But on top of that, some searches of the IP Australia Trademarks Register as well. Because that's the register that shows all pending applications as well, so as well as registered trademarks. So that might shed some light on kind of whether other businesses have attempted to register that mark already, or whether they've got kind of pending rights there. And yeah, so once you've settled on a name and it looks like you're clear to proceed, get your application filed as soon as possible. This will give you your priority date. So your filing date is kind of your place in line. And even though the registration process in Australia and across the world, it takes a number of months. In Australia, it's about 7.5 months to get fully registered. Having your priority date is giving you, as I said, your place in line above anyone else who will file after you. So that's really important. At that stage as well, it is important to think about kind of your target markets overseas. Where are you going to be offering your goods and services? Because trademark registration takes place on a country-by-country basis. So you'll want to start thinking about, yes, filing an application in Australia if this is kind of your home-based country where you want to start initially providing your goods and services. But if you've got plans to expand or offer your services or goods you know, to international customers quite quickly, getting your applications filed overseas and getting that priority date secured overseas is also really important. Places like Canada take 3 years to get a registered trademark at the moment, and the US is about 12 to 15 months. So there are some significant delays overseas. Yeah, best to get in early there. The other thing I would be thinking about at the early stage is kind of capturing as well in your application, capturing the range of goods and services that you do want to be providing, because trademark registration is done in terms of classes of goods and services, so you need to kind of specify the exact goods and services for which you'll use your trademark. And it's good to kind of think a bit more long term here to the next kind of few years. Think about your goals for expansions to make sure that your protection is robust now, and so that you don't come a couple of years down the track and realize that your trademark's not actually protected for what you're doing. And then, you may be kind of offering kind of a limited version of what you intend to do now, but think long term there. In terms of, I think there was something else I was going to say there. Oh yeah, the other tip I had from the beginning, from the outset, I would recommend as well, once you've done your searches, once you've decided on a brand, even if you haven't lodged your application yet, you can start using the TM symbol. The TM symbol is just an indication that you consider that a trademark of your business, or that you intend to claim rights in that trademark. It doesn't mean that you have registered rights, so you can't enforce that as a trademark yet, but it does put people on notice of your trademark, or of your intentions to claim that as a trademark. So that's a really kind of common misconception in the market. If you see a trademark with a TM symbol on it, the average person would be deterred from copying that because you think that's protected. But it's just a sign to use to indicate that you intend to claim that as a trademark. When, or hopefully when, your trademark then does become registered, once it progresses through that life cycle, that's when you can start using the registered R symbol, so the capital R in a circle that you'll see. And that is a sign that your trademark's registered. That's when you can enforce your trademark rights, but you crucially cannot use that until it is registered. It's illegal to use it until it's registered.
Great, and hopefully there's no issues that happen once you've protected your brand, but if it does happen, how can a business owner enforce their intellectual property rights and without making a really costly battle?
So, I guess one of the key things you can do, which I just mentioned, is just putting competitors and others on notice of your rights by using those symbols. It can act as a deterrent straight off the bat. But then beyond that, obviously trademark registration is going to give you the easiest avenue to enforce your rights, because that kind of automatically is proving that you have ownership in that trademark, in that piece of intellectual property. Otherwise, you're going to have to jump through a number of different hoops to prove that ownership in court. So it's the easiest way to enforce that your rights, and it has kind of the lowest thresholds to prove ownership of. So, sorry, yeah. Oh, sorry.
I might just come back to you, and
Yes.
we've got a Q&A time. So yeah, really helpful question.
Yeah.
Thank you. But I'll call on you in a moment.
Yeah, no, that's right. Where was I? No, that's all right. So in terms of trademark registration, that's the best thing to secure early on to enforce your trademark rights. It's going to be the easiest thing to prove if you did get to court, but as well, if you do have that trademark registration, you can then do things like issue cease and desist letters really easily by just engaging a lawyer or doing it yourself to send a letter to the party that you believe is infringing upon your registered rights, and asking them to stop using that, to cease using that and desist from using that further, which can involve them kind of destroying all kind of goods that may bear that infringing trademark. So sometimes a letter like that can be enough to scare people off, and that's enough. Or perhaps you engage in some further settlement negotiations from there in terms of a rebrand for them. But that's where having the upper hand and having that registration is really important and puts you in really good stead. Oh yeah.
I was just going to say as well, if you're in a business that's selling like physical products, you can also take steps to register, say, your trademarks or sort of other IP with local customs authorities. So they can't actually, when they do their sort of inspections and things like that, they actually don't have any authority to do seizures or anything like that unless you give them that authority. So if you are in a business where you've noticed that your physical products getting infringed or imported into the country, then you can let the relevant customs authority know. There's sort of a process depending on the jurisdiction, and that gives them that authority to actually seize and destroy infringing goods, and they'll obviously let you know who the importer is so that you can then maybe take separate action if you need. And that's the same for things like any sort of like those online platforms like Facebook or Amazon. You're selling products through there, or you've got ads running through there that are getting sort of infringed or copied. They also have sort of brand protection portals or pathways that you can register for with your trademarks in order to kind of protect your rights that way too, which is another sort of low cost means of, I guess, protecting your brand and your goodwill.
One more thing, sorry. The other thing you can do as well is just monitor the marketplace, monitor for infringement yourself. If you notice someone that you think is copying your brand or is using something really similar, just make notes of that, make records. But then I would encourage you to speak to a lawyer to see if there is a claim before you approach them directly. Sometimes the risk could be that perhaps you notify them too soon while your application is maybe going through the opposition period, and then they're unduly notified of the fact that you've got a pending application and they're also using a similar mark. They may want to oppose your application. So just be really careful before approaching another party who you may think is copying you. Just get some advice around whether you have that claim before doing that.
Before Stephen and Sophie keep adding on top of each other, Tom, I'll give you one more chance. Sophie mentioned about IP ownership and thinking through that. Could you tell us how we could use our business structure to protect intellectual property?
Definitely. So quite a common structure in, especially with companies, is having a multi-layered or a dual company structure. Whether or not it's necessary for your particular business depends on a number of factors. But broadly speaking, that's where you have a holding company sitting at the top, which wholly owns an operating company. And generally in these types of structures, the holding company, as the name suggests, holds all of the important assets, including your intellectual property. And then the operating company sitting underneath is the entity that's actually doing the grunt work, the day-to-day operations, with the idea being that when it comes to making a claim over anyone, you can usually only go after the entity or the person that you have the relationship with, the contract with, basically. And the idea is that the operating company, it doesn't own anything. So if anything was unfortunately to go wrong within your business, it would happen at the operating company level. The operating company doesn't own anything. So therefore, the important assets of the business are sitting pretty up in the holding company level. So it is, structure is a great way of being able to protect your intellectual property. If you are having a multi-tiered structure like that, it is important that you get advice from a lawyer, especially if you are going to go down the road of, say, looking at the R&D tax incentive or trying to get under the early stage innovative company concession, just because there can be some issues that come up with those types of structures, because there's a bit of a disconnect between the entity that actually owns the IP and the entity that's actually doing the development, with the ownership at the holdco level and the activities happening at the operating company level. So there's definitely strategies that we can put in place to mitigate those types of issues that do pop up, but they are things that we've seen more recently that the ATO is cracking down on. So yes, definitely good for IP ownership and asset protection, but they don't come without their own toothaches. So definitely get in touch and we can walk you through those.
Great, thank you. So what we're going to do now is, in a few minutes, we're going to have some time for Q&A. So any questions that you've got, please feel free to raise your hand. We'll have a mic coming around. But in the meantime, just wanted to capture what we've just said tonight, hopefully for some takeaways for you to actually go and implement. So first of all, for contracts, make sure that each party's obligations are very clearly defined. This will help prevent disputes, which will later turn costly. So make sure that everything's very clear. Most of those disputes arise because of misunderstandings about responsibilities. And then make sure that you understand the regulatory environment that you're in to ensure compliance and success. If you're not sure, if you're in a regulated industry, that's something to look into and to work out, actually, do my contracts have to comply in particular ways? When you're thinking about corporate and tax, make sure that you're choosing the right business structure based on your business plans. And just remember that contractors may be considered employees under tax and employment law, even if you don't want them to be. We have to work out what it actually looks like and what the ATO is going to think about. So just make sure that you as the employer are compliant and make sure you don't risk those significant penalties. And then finally, when you're thinking about your branding, a good tip is to search for those trademarks or that brand name early on. The earlier the better. You get a priority date as soon as you lodge your trademark application. And so make sure you register your trademarks to protect and enforce those intellectual property rights. Makes it a lot more straightforward and a lot cheaper for you if later down the track there are any issues. The other thing I just want to run through is to join us for our next event about the power of branding. So if Sophie's talks on trademarks got you excited, please join us on Wednesday the 23rd of October at 6 o'clock. You can register same way that you registered for tonight's event, but that one will focus on specifically thinking about how you can build and protect your brand. And the other thing I wanted to talk about is our membership. So what we do is we work with a lot of startup founders like yourselves who are asking these kinds of questions that have come up tonight, thinking about how do I structure my business for growth and success? How do I protect the brand that I've invested in? And how can my contracts protect the relationships I'm in and make sure that I can meet my goals over the next few years? And so what we do is we normally meet with you in a complimentary consultation, work out what are your plans, because no two businesses are alike. And so as these guys have actually pointed out, a lot of it is based on what are your plans. And so we'll meet with you, sit down and give you some sort of roadmap about what will be your priorities over the next few months. If you're kind of a way off from launch or anything like that, that's okay. You could still meet with us, get a plan, and then think about your legals when you're ready. But the important thing is to think about it early so that later down the track you're saving yourself time and money. So what you can do is there's a few of us around here if you want to find out more about this membership, but it's designed to give you unlimited access to contract drafting, reviews, as well as trademark applications, as well as business structuring advice and unlimited consultations. So any questions that you have for any of our lawyers, including if you have questions about what industry is regulated and whether yours is or not, you can use this membership for that. So you can book a health check. If you want to find out more, you can chat with me tonight or Nick at the back. He's going to wave his hand. Yeah, there you go. And or go onto our website and you can book a meeting with us. We're keen to chat with you and see how we can talk you through the process and give you that information. So now I'm going to open it up to, that's how you can book it. You can book it through the QR code. But now I'm going to open it up to questions. So maybe we'll start with your trademark question. I will just give you the microphone.
Hi everyone, I'm Kate. So my question is around trademarks. So sorry, you're in hotspot. My understanding of trademarks is that you have to use it, or it's not actually going to be applying. So if somebody can prove you're not using it, it's gone. So going to your advice for early on, applying for trademarks broadly, what happens if you haven't actually yet started doing something that you think your company will eventually be doing in the next 6 months? How would you kind of counter that claim from someone else?
It's a really good question. So in Australia, you're given a 3-year period to actually start using your trademark before it's vulnerable to removal for non-use. And even then, it will only be removed if a third party wants to remove it. So say your trademark is actually blocking theirs, then and they notice that you're not using it, they may want to remove it so that theirs can be accepted, essentially. So yes, there is a use requirement, but then it's kind of like, even if you're not using it and no one else wants to use it, then it will remain registered.
If I've set something up as a sole trader and I've got contracts with customers and trademarks and things already registered and so on, how much work is it to suddenly change structure now that the business wants to get bigger?
Yeah, no, it's a really good question. And look, I have to be honest, it's not the quickest process in the entire world. Doing a corporate restructure does take a bit of time. Depending on what the state of play is, you'd have to work through what the actual tax implications are. Because essentially, if you are looking to move to a different structure, you're selling a business that you own to a different structure, which is something which does trigger capital gains tax ordinarily. That's not the end of the line. There are ways to get around that. But even if you put aside the tax things, if you have contracts on foot, things you'd have to think about are things like whether or not there's any approvals you might need from the other side to get those moved across. Particularly things like leases often have change of control clauses. So all of that is just things you'd have to work through just to make sure that the other party is actually okay with that happening. Things like trademarks, it's a matter of just transferring it to the new structure. And I mean, Sophie can speak to this better than I can, but then updating IP Australia, not 100% sure how long that actually takes. But usually when we work through these types of bigger restructures, where there is a more established business on foot in the existing structure, it does take a couple of months in total, but we can certainly, work through step by step along the way.
And then I guess to add to that as well, if you are sort of thinking about it, one of the best places to start too is to kind of look at your customer contracts and identify, assuming that they're on maybe their terms and not on sort of your standard form template, but identify maybe your large contracts, the ones that account for most of your revenue, because it's really good to check through those. And Tom sort of touched on it around sort of change of control or anything like that, change of ownership. Some contracts will have that provision that says, if you go ahead and change things and change the control of this business without telling me, then I have the right to terminate the contract, which is not something you really want for your most critical or your highest sort of revenue deals. So that's really important. The actual transfer paperwork and things is quite straightforward. It really depends on, I guess, maybe what the industry you're in and what sort of risk, of business you're doing. So, you can just, in most cases, sort of assign a contract, which is kind of, in a sort of a general sense, kind of a one way of doing it, but it's not kind of an absolute sever of liability. Not exactly from a legal perspective, sort of substituting yourself out for the new entity. So there's usually sort of a three-party agreement that would be done. It's called a novation, and that essentially, is you kind of walking away, someone else coming, that new business structure coming in, and the party that's staying, which is usually your customer or supplier, kind of consenting to that, and that's kind of the cleanest break that you can get. But it is obviously a lot of admin to do, which is why a lot of people sort of take the risk and they'll, do an assignment and just sort of kind of transfer as much as they can, and then in their sort of business transfer documentation, they'll deal with liability separately and allocating that risk.
From a trademarks perspective, it's really straightforward as well, so it's good to know. So either you can, if you're kind of transferring from a sole trader to a newly incorporated company, there is a thing called a letter of assignment that you can download from IP Australia's website, and essentially that is just you transferring it to the company. If it's really straightforward, they'll allow that. But if you've started to actually use the trademark, usually there's a bit of goodwill that you've started to accumulate under that, so it's safer to set up kind of a full IP assignment agreement between you and your company, and then we just lodge that with IP Australia to record the transfer formally. But it takes about a day to actually reflect on the register, so really quick.
And can I just add, even though I'm not really on the panel, but yeah, it's super common. We get lots of people who start off as sole traders because, for tax reasons and other reasons, it makes more sense at that stage, and then turn into company structures. So all of these are just part of that process, and some of it is just administrative, tedious, but it's part of that process of growth, and so it makes sense.
Hi, it's Martin. Tom, you mentioned earlier a 20% reduction for investment and a no CGT for selling shares. Curious to know a bit more.
So yeah, that particular concession is available for investors who buy or subscribe for shares in an early stage innovative company, or ESIC for short. So they are quite good concessions, as you can appreciate, to get under if you are eligible, but there's a bit that goes into figuring out if the particular company itself is an eligible company. But if it is, and if the investor also meets certain conditions, there's a cap on how much an investor can invest in a particular year, how much they can actually hold in the particular company. But assuming all things are going well, and that all the boxes are ticked, then in the financial year that the investor subscribes for the shares, they get a rebate or a rebate in their own tax return up to 20% of their investment, up to a $200,000 cap. So let's just say that their investment's for $200,000. 20% of that is $40,000. So they'd be eligible to reduce their own tax liability by up to $40,000. And if they don't use that full amount, they can carry that forward for future years. And then the modified CGT treatment is essentially when you sell shares, it triggers what we call a CGT event, and then you have to go through the song and dance of figuring out whether or not you have to pay any tax as a result of selling those shares. But assuming that there would be a capital gains tax liability, if the investor has held their shares for more than 12 months but less than 10 years, any capital gains tax implications as a result of selling those shares is completely disregarded. So ordinarily an investor who sells their shares would have to pay usually some tax on a sale of the shares if those shares have gone up in value, but in the event that those shares are shares in an early stage innovative company, then there just is no CGT treatment. With the idea being that the Australian government wants to incentivise growth and encourage investment in these, for lack of a term, riskier companies. So I think one thing to bear in mind, particularly with the modified CGT treatment, is that a realistic statistic is that a lot of these companies do fail because they are doing something which is new and it's risky. So even though those are available, not every investor gets to use them, but they are a great concession to get under if they are available. And it's something that we do advise on quite a lot because a lot of our clients are doing new and exciting things.
Good point, actually. But when you say early stage, what is early stage? So are you saying less than 10 years of the inception of the company? They can apply for the discount, yeah? 20% of tax benefits. Is that right?
Kind of, but not really. So the company, you kind of split it into the two stages. So there's the early stage part, and then there's the innovative company part. So to be considered an early stage company, the company has to be less than 3 years old and have income and expenses of under a certain amount for the previous financial year. That 3 years can be pushed to 6 years in certain circumstances, but it gets a little bit tricky then. So yes, you are right that there is an age limit on the company itself. So if it's under 3 years, then yes, provided that the other expenses and income requirements are satisfied, which are $200,000 or less of income in the previous financial year and less than $1 million in expenses in the previous financial year. And both of those numbers are across all of the entire corporate group. So for example, if there was a holding company with 5 subsidiaries, all of their income and expenses are taken into account there, not just the particular company. So yeah, but then the actual 10-year requirement, what the ATO looks at is what was the state of play on the day that the shares were issued. So if the company was an eligible ESIC at that stage, it doesn't matter that in 10 years' time or just under 10 years' time, the company isn't an ESIC then, because naturally it won't be, because it'll be closer to 10 years old. So provided the conditions are met on the day that the shares are issued, that's when the concession is available, even if the sale happens much later. Does that answer your question?
you can book a legal health check and talk to Tom, would be my answer to that one.
Okay, yeah, question for Stephen. One of the key things when you're starting a business or running any kind of business is getting paid. In the excitement, how do you make sure that you get security over payment from your customers?
It's a good question. It can vary depending on, I guess, what industry you're in as well. If you're in an industry, for example, that deals, let's say you're in, you're dealing with goods and you're selling goods, one of the most important things, for example, is not transferring ownership of those goods until full payment, because in doing so, and by retaining that ownership, you have a security interest. And if you have a security interest, then you can usually register that interest on the personal property securities register. And in doing so, basically, in the event, there's some sort of insolvency event, your interest kind of bubbles up to the top of the priority list, and you're not sort of fighting for anyone else or amongst sort of other unsecured creditors. So that's sort of, one aspect. There's obviously ways in which you structure your, maybe your payment terms or how you get paid. So a lot of clients might opt for things like, upfront payment as an example, or if they're doing sort of a large project, working in milestones, so having smaller statements of work and kind of smaller deliverables or smaller milestones, so that as soon as there's a credit risk or some sort of, I guess, default or lack of payment, you can kind of stop work tools down, and having those clear rights in the contract as well. I know most contracts that we draft will have standard provisions that say not only can we charge you late payment interest if you don't pay us on time, but also that we have the right to suspend the delivery of services. And that's actually really important to put in there, because if it's not, there may be a claim made against you that if you just stop work and you don't actually have the right to do so, without sort of going through the formal breach notice provisions, that you're actually in breach yourself by not performing. So having that right to suspend is really important. In terms of, I guess, if, despite all those things, you're still not getting paid, a really great tool is a letter of demand. The threat, or I guess gentle reminder from a lawyer that there's an outstanding payment is actually really effective in most cases. A lot of the time, non-payment doesn't come from things like, it can come from things like insolvency or poor cash flow. A lot of the times people forget. I've had a lot where they, it's just been stuck in the mechanics of a finance department somewhere, and then it's not until a letter of demand comes through that it suddenly gets all the way up to the top and paid very quickly. So those are really useful tools as well. And I know we send out quite a few of those for clients. In fact, I think we have now a dedicated paralegal for starting to prepare those letters, just because of the sheer volume that you get in that respect. So that sort of stuff is really important. So there's kind of steps you can take across that cycle.
Yeah, my name is John. I got two type of question. First thing is about early stage of innovation. And I got a company that set up 2018, and we start to develop the platform during the COVID. And then now nearly 4 years, and we got the product which is MVP already. And is this how gonna work? Because previously we haven't done anything with that company, and then the platform start to develop from my real estate company, and I transferred to the old company which I own, and we are just going to market probably end of the year or next year. I'm not sure if I can get some kind of a tax benefit. That is my first question. But second one is because we're preparing for the fundings, and if I raise like 3 million target, and how does it work? Really, like the valuation of the business, and yeah, I got someone suggesting like 30-40% only minimum, like that's only I release it, but I don't know how does valuation work for like tech. We got a real estate platform that want to raise 3 million for the next stage.
I might jump in quickly on the second one. In terms of valuation, it's not sort of our expertise in terms of actually how all the valuation metrics that would take place. We definitely have, I guess, partners we can put you in touch with, or anyone who's interested in terms of getting, maybe a proper valuation of your business done. It's obviously really important for tax purposes if you're thinking about doing restructuring or business sales, things like that, to understand your tax, potential tax liability or any sort of tax consequences from that point of view. I mean, I can let Tom speak to the first question. Obviously, can't give you sort of personalised advice because it sounds, from just talking or listening to Tom, just saying there's lots of ins and outs and exceptions and holes in the ESIC regime. But I don't know if, Tom, you've got any sort of high-level aspects you can sort of share on maybe what happens, for example, or what sort of common things do you see that trap people and why they don't qualify for that sort of ESIC status, and if someone puts their business on hold and resumes, does that have any play as well?
Yeah, thanks Stephen. So I mean, the age is obviously, in this case, it is the thing that might be what is the difference between the company being considered early stage or not. When it comes to ESIC, apart from a few different things, but for the most part, the ATO looks at the company itself, not all of the members of the group, as I say, with certain exceptions to that. But so, I mean, the traps that can often arise, particularly if you do go through a restructure to try and reset the age of the company in a way, maybe moving the IP into a different company or, putting a new structure in place, whatever, is that a lot of the tests when it comes to ESIC do look at the activities of the company in a previous income year or a previous financial year. So in doing that reset, you've all of a sudden got a company that might own the innovation and the product, but it doesn't have a previous income year to look to, and it doesn't have any previous history. It hasn't done anything. So there can be a bit of fancy footwork to make it work if the company has aged out. As Stephen said, there are a lot of ins and outs within ESIC that we work through quite a lot with a lot of our clients. So I would say in that regard, it would be worthwhile having a chat to us, and we can maybe see if we can pull a rabbit out of the hat if the company has aged out. But given that there is a 6-year limit in certain circumstances, particularly if the company hasn't done a whole lot in certain periods, maybe the company could still get under the 6-year rule instead of the 3-year rule, so it's not the end of the line if it was incorporated in 2018, I think you said. So yeah, that would be my take on that.
Great. Well, I'm just going to stop the questions now. But yes, please feel free to, if you have any follow-up questions or you want more information, we do have the complimentary consultation. So I encourage you to book it if you've got any more questions to ask later. One other thing that just came to mind is you may have already come across it, but we have a startup manual available on our website. And so that details a lot of what we've covered tonight, but as well as some case studies that might be really helpful for you as you think about your business. So please feel free to download that. That's free, but it's something that's one of our most popular resources amongst startup founders. So please feel free to do that. After tonight, we will send you an email with a survey asking you how you found this evening, what was helpful, what we could do better. It's really helpful for us because we are running these events, as you saw, the branding one, and we're keen to make it as useful as possible. So please take a couple of minutes just to give us that feedback, let us know how it went. And what you'd like to see more of in the future. And please stick around afterwards, have some more food, have some more drinks, chat with each other, chat with us. If you want to find out more about the membership or the consultation, feel free to chat to any of the LegalVision team members here now. But otherwise, yeah, we can head off around 7:30, but please feel free to hang around for now. I'll just give a round of applause to our panel. Thank you. And thank you all for coming tonight. Please stick around for a bit longer.